It's one of the first things you learn in law school. And most lawyers in my experience, and all lawyers in my experience of the department, take it very, very, very seriously. It's one of the most important parts of the whole rules of civil procedure in my view. When I heard the testimony that Rule 11 would not support going forward in this case, my blood boiled, because I've never done anything like that in my life and never will. And for someone to assert that a pleading we signed in something this important could not be ethically supported was a very low moment, and it is false.
Has anybody, at any time during your time at the department, with regard to the Black Panther case, ever to your face accused you or any other member of the trial team that you're aware of having violated Rule 11?
Of course not. And there's so many procedures in place. For example, if Rule 11 was at risk, why isn't there an OPR investigation of Christian Adams and Christopher Coates and Robert Popper? There's an OPR investigation of somebody else, but it's not us. If there's a Rule 11 violation here, then bring it on, because we didn't do anything wrong.
One of the things that you have mentioned in the two articles that you wrote immediately, or last week or so, one with the Washington Times and then Pajamas Media, you mentioned an incident where the remedial memo or other memos were thrown at Stephen Rosenbaum by Chris Coates. Can you tell us about that?
Well, I could. Again, I hardly consider profanity and assaults to be, and I'm using the term assault in the lightest of terms, it's a piece of paper, could be considered deliberative process. It's kind of a lack of deliberation. Mr. Rosenbaum told Mr. Coates, and I'm sure Mr. Coates would testify under oath if he were able to comply with the subpoena, that he hadn't even read these memos.
He, Rosenbaum?
That's correct, before he began to argue against this case. And Coates was so outraged, he said, "That's bullshit. How dare you? That's bullshit." And Coates threw the memo at him and said, "You can't do that."
Who is Steve Rosenbaum?
At the time, he was the acting Deputy Assistant Attorney General for Civil Rights.
Had he been assigned to the voting rights section any time before then?
15 years ago, he was in the voting. I think at one point he was an acting chief, but I'm not sure about the chronology.
But immediately before this election, before 2008, was Steve Rosenbaum in the voting rights section?
Yeah, I think he was 15 years ago, maybe
Okay.
14, 16. But I wasn't there. I can't tell you exactly when.
To what section was he assigned
At the
during
time?
the election? Yes.
Okay. He is currently the housing chief in the housing section, housing and civil enforcement, which has, of course, nothing to do with voting, and has been in housing for a long time, but I don't know exactly when he started.
Okay. Now, the incident you mentioned about the throwing of the memorandum, were you there?
I was not, but as I said, if Mr. Coates were allowed to comply with the subpoena, and if Mr. Popper was sitting in this chair right now, I have absolute certainty that they would say this, and it's not hearsay that Mr. Coates and Mr. Popper told me this. It's hearsay what happened, but it's not hearsay that I was told this.
During this period, from May 1st when the case gets extended, till May 15th when the response is due to the court, did you become aware that the appellate section was asked to review the case as well?
Well, that's one of the questions that will deal with something involving the deliberative process that I'll not answer.
Okay. Well, before you should have Exhibit C, which is another document that we received through our investigation, which purports to be an email from Diana Flynn. Also includes supporting information from Marie McElderry. Do you know who those individuals are?
Excuse me. Diana Flynn is currently, as far as I know, the chief of the appellate section. I don't know who the other person is.
Right. Do you know whether Diana Flynn is a career employee?
Yes.
In that memorandum, it states, at beginning numbered paragraph 1, and this is from the appellate section.
Can I interrupt you? The
Yeah.
answer to my last question simply said whether I knew she was a career employee.
Yeah.
I do know whether or not she is, and the answer is yes, she is a career employee.
Okay.
I've read too many depositions.
All right. Going back to Exhibit C, which is purports to be a memorandum, a an email from the appellate section. Ms. Flynn indicates, quote, "We can make a reasonable argument in favor of default relief against all defendants, and probably should, given the unusual procedural situation," close quote. During that time, between May 1st and May 15th, did you become aware of the opinion of the appellate section?
I have seen this document before.
All right, but at that time, were you aware of it?
Yes.
Okay. At that point, then, you have the trial team, Mr. Coates, Mr. Popper, yourself, Mr. Fisher, and also now Diana Flynn and Marie McElderry. All 6 are career employees, and all 6 say the case should go forward. Is that correct?
I won't dispute that.
Is it unusual to have 6 career employees overruled like that?
Well, if you listen to the press accounts from the Bush administration, you'd think it happened every day. But it really didn't. It is unusual.
Have you ever heard of the appellate section reviewing a case that was in a default procedure or default status?
In my experience, no, and I'm quite confident if Christopher Coates was sitting in this chair and were able to comply with the subpoena, he will tell you the same thing. And he's been there since 1996.
Was there any indication that anyone higher up than Loretta King or Steve Rosenbaum was making the decision to override the 6 career attorneys who said the case should go forward?
None that I had any indication of.
When you were told, or the trial team was told, to dismiss the claims as to 3 of the defendants, was any reason given?
Well, I mean, listen, you had Assistant Attorney General Perez come and tell you what he told you in his testimony here. And as I indicated, those were not unfamiliar arguments to me.
All right. But you're, as of today, you're not in or don't feel free to testify exactly what you were told at that time.
I will not.
Okay. During this process that went on between May 1st and May 15th, were there emails that you saw, documents back and forth discussing the merits of the case?
Well, that gets back into things I won't testify about.
I'm not asking about the substance, but is there a paper trail out there?
There are large volumes of documents about this case.
Okay. You don't have those documents, is that correct?
No, sir.
They're back with the department, is that right?
Or wherever else they might be. They may be at the assistant's office. I mean, they're mostly electronic. I mean, we reduced everything. The department has this wonderful software package called Summation, where we crank everything into Summation so it can be text searchable. Now, there was a lot of video, obviously, if you look on the web, and those don't lend itself to Summation quite as easily. But nonetheless, everything was converted to electronic. Because when you go to trial, you want to have everything electronic, and you might as well do it at the very beginning. There's no sense in saying the month before trial, let's convert everything electronically. We were cranking things electronic as we got it.
Okay, so that would include this electronic database, if you will, would have not only the information about the substance of the case, but also the communications back and forth between the trial team and higher-ups.
Probably, but I'm not sure. About the latter part of your question, about communications, I'm just not sure.
Okay.
Those will be electronically, but maybe not in that database.
During the decision-making process about the Panther case, did you hear that anyone at the department was consulting with any outside groups, such as the NAACP Legal Defense Fund?
Well, I did, but we were also consulting with outside groups. We visited the Southern Poverty Law Center. We visited the Anti-Defamation League and would have probably hired them as an expert in this case if it had gone forward. Because, of course, the Black Panthers they're a militant anti-Semitic group. They're not just black nationalists. They hate Jews. And the ADL has an extensive database on this organization.
But your communications with ADL and the Southern Poverty Law Center, I assume, were related to the substance of the case.
That's correct.